YouTube. Good morning. Welcome to the First District Court of Appeals. We have several cases on our docket this morning for argument. First case to be argued is Gardner versus Ohio Department of Job and Family Services. Mr. Barnes is here on behalf of appellant. Ms. Sullivan is here on behalf of appellee. Mr. Barnes, you will have 15 minutes to argue this morning. Would you like to reserve any time?
Yes, 3 minutes.
All right, and I will keep your time whenever you're ready to begin.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, my name is Matthew Barnes, and I represent the appellant Kelly Struck as administrator for the estate of Diana Gardner. This appeal is before the court today because Ms. Gardner's long-term care Medicaid application was denied due to the value of her real property exceeding the resource limit. The primary issue before this court is whether the lower court erred in affirming the administrative appeal decision that upheld the denial of her Medicaid, even while Ms. Gardner was attempting to make efforts to sell the real property without ever applying the reasonable efforts exclusion. The secondary issue is whether the lower court erred in affirming the administrative appeal decision that Ms. Gardner's real property was still a countable resource, even though it did not fit the definition of a countable resource when she did not have a willing and able buyer.
Mr. Barnes, may I interrupt you? Is your argument the same no matter what the value of the real property is? In other words, if someone had a $26 million piece of property that they were unable to sell because nobody really wanted to buy it, would you be making the same argument?
Yes, Your Honor, because that is the requirement under the federal statute. And Medicaid does have other ways of collecting back in those kinds of situations. For one thing, if that person who owned a mansion house, something worth a lot of money, they were to ever sell the property while they were still alive, they would be off of Medicaid until they could spend down $26 million on their own care. Or if they were to pass away under the Medicaid estate recovery program that Medicaid has, anything a person owns the moment they pass away can be collected by Medicaid, unlike the SSI program. The SSI program does not have nearly as extensive of an estate recovery program as Medicaid does. And of course, that is discussing payback provisions, which SSI has their own version of as well. But the primary issue here today is really eligibility. It's what allows somebody to become eligible for benefits in the first place. When it comes to the payback provisions of how does a program recover for the costs of what it costs to provide these kind of benefits to people, especially in the case of a mansion house, Medicaid already has some provisions about that. But when it comes to eligibility, the federal statutes are very clear, and so is Ohio's own Medicaid state plan, that a reasonable efforts exclusion would be required in all those types of cases.
In this case, on our prior case of Cohen, are you asking us are you telling us that that was wrongly decided and we need to rethink that case, or are you distinguishing that case here?
Well, as regards to Cohen, there is some parts of it that are distinguishable. For one thing, the reasonable efforts exclusion was never analyzed in Cohen. They were only looking at, the court was only looking at the definition of resources are the SSI regulations, whereas, again, the federal statute 1382B, which requires a reasonable efforts exclusion, was never really examined. And that's critical to determining whether or not it should have been applied in this case, as well as the Ohio Medicaid state plan, which again just reiterates what's in the federal statutes. The Medicaid state plan just says, because again, Medicaid is a joint federal and state obligation. It's not just a state obligation. It is a joint federal and state obligation where there is a contract, the Medicaid state plan, that lays out what the state's obligations are with regards to those federal requirements. And so it lays it all out much more clearly. And that was never examined in Cohen. So there are some aspects of Cohen that we believe are incorrect just because it wasn't examined under that light. It didn't have all the information. And Cohen did acknowledge they didn't examine the Medicaid state plan in that decision. Again, because Medicaid is a joint obligation between the state and the federal program, what is laid out in the federal statute matters. And the relevant federal statute is 42 USC 1396A. That lays out the Medicaid state plan requirements, what states who are implementing Medicaid must do to meet their federal obligations. And under 1396A, when it comes to the resource requirements, 1396A specifically cites to 1382B. That's the SSI resource eligibility requirements as to the type of methodology the state has to use, or at least be no more restrictive when implementing when it comes to long-term care Medicaid applicants like Ms. Gardner. And 42 USC 1382B2 is where you find the reasonable efforts exclusion, which says if somebody owns real property, if they're making reasonable attempts to sell, then that property cannot be considered a countable resource. Now, Medicaid is a needs-based program. It does provide medical care for those who can't afford it. And it's similar to SSI in that way. SSI is also a needs-based program. They're going to be looking at a person's income and resources first to determine do they meet those thresholds to qualify for benefits. The big difference with SSI being that it pays out cash benefits instead of medical benefits. But beyond that, they are similar programs.
Would she be eligible under, if she could prove reasonable efforts to sell the property, would she be eligible for SSI?
Yeah, so under the SSI rules laid out 1382B, they would at B2, they would consider whether she had made reasonable efforts to sell the property. Now they do set out their own requirements. The commissioner sets out their own regulations as to what it means to make reasonable efforts under SSI's definition. But while those regulations are out there, when it comes to Medicaid eligibility, the state only has to implement it in such a way that it's no more restrictive than SSI's methodology. So if she was applying for SSI, her real estate would have been examined for the reasonable efforts exclusion. Since it was never actually done, I'm not exactly sure, but it looks like she would have a good chance at least at qualifying under SSI. And actually, one of the tests that 1396A lays out, again, this is the Medicaid statute. It says, when it says you can't implement Medicaid eligibility that's more restrictive than under the SSI methodology in 1382B, it does say it can be less restrictive, and it sets out a test to help determine when it might be more restrictive. And the test is, if somebody was applying, you had an applicant applying for SSI and Medicaid, and they would qualify for SSI, but they wouldn't qualify for Medicaid, well, that's a sign that your Medicaid eligibility requirements are being too restrictive. And in this case, Ms. Gardner did make reasonable efforts to sell. In December of 2018, she listed her real property for sale with a real estate agent, and she only entered the nursing home in March of 2019. After she had spent down her other resources to under $2,000, she applied for Medicaid in August of 2019. In September of 2019, she was denied because of that real property in West Virginia that she owned, putting her over the resource limit. And even though she did appeal at the state hearing and administrative appeal levels, neither of those levels did they ever consider her reasonable efforts to try to sell that property as qualifying for the reasonable efforts exclusion. And again, that test is...
Sorry to interrupt, but can I ask, so my understanding under SSI is that if you are making reasonable efforts to sell, there's this 9-month period, I guess conditional benefits period, and then if you ultimately sell, you would have to pay back the 9 months of benefits, right?
Yes, Your Honor.
Now,
yes,
in this case, if we were to find that there is a reasonable efforts exception for Medicaid, would there be any kind of payback if she were ultimately to sell that house?
Well, at this point, Ohio does not have in their regulations what the reasonable efforts exclusion looks like. So whether there's a payback provision or not, I'm not sure if there would be. It's possible. I mean, when looking at other 1634 states like Ohio is when it comes to how they determine Medicaid eligibility, some states do have payback provisions, just like SSI does, and some don't. Again, because they don't have to be as restrictive as SSI. So Michigan, for example, does not have a payback provision that's required for the first 9 months. So whether she would be required in this case, it's an open question. But what is required is that the reasonable efforts exclusion be examined and applied to Ms. Gardner. Again, in 2016,
That's all you're asking us to do, right? I mean, you're not asking us to go any further than that.
yes, that's all. Is that this needs to be remanded back to the trial court, which can then remand it back to ODGFS to examine her reasonable efforts to see if it would qualify for the reasonable effort exclusion that's required under federal law.
But do I understand you right to say that Ohio doesn't have any payback, and that's because they haven't applied it in the way that you're suggesting? Is that an oversimplification, or is that what you're saying?
As to why they don't have a payback provision like SSI does for a reasonable efforts exclusion, I'm not sure. They don't have one, and I'm not sure why. I mean, as of 2016, they used to have a reasonable efforts exclusion, and that one did not have, at that time, there was no payback provision in that one.
Why was that taken out?
I am not sure. I'm guessing it had something to do with the fact that at that time, Ohio converted from a 209B state, which allows a state to have more restrictive eligibility requirements than SSI, to a 1634 state, which now puts it into a different realm. And during that shift, a lot of different regulations had to be rewritten to make it conform with the new requirements. A lot of things were rescinded. A lot of things were modified to kind of mirror SSI statutes and regulations. So it happened at that time. It happened during that shift, but I'm not sure.
You have 1 minute left if you'd like to reserve 3.
Okay, thank you, Your Honor. Yes, I'll still reserve 3. It should also be noted that Ohio has statute and regulations that also say Medicaid eligibility has to be determined in accordance with this Medicaid state plan as well. So this is in accordance with Ohio law. They're also requiring this resource exclusion to be applied. And again, second, we would say that Ms. Gardner's real property still was not a resource, accountable resource under the definition, Ohio's own definition, because there was no willing and able buyer. Cohen and Community Care did address this issue, but not in the light of SSI methodology, which is relevant to Medicaid. Under SSI, a real property is non-liquid. And when you look at the fact that it's non-liquid, it makes sense that legal ability should mean more than just legal authority to sell. It should mean you have a willing and able buyer out there. As Kinsey noted in their analysis at the Logan County Common Pleas Courts, this was decided after Community Care and after Underwood. They found that a life estate was not a accountable resource, even though when the applicant had been listing it for sale.
Mr. Burge, you are at your time.
Okay, thank you.
All right, thank you. Ms. Sullivan, you have 15 minutes to argue.
Thank you, Your Honor. May it please the court, Assistant Attorney General Angela Sullivan on behalf of the Ohio Department of Job and Family Services. The lower court correctly held that Ms. Gardner's construction of the law is mistaken because she relies on a portion of the Social Security Act, 1382B, which does not apply to Medicaid law, specifically the conditional benefits portion. This court should affirm the lower court's decision, which correctly held that the agency's decision was supported by reliable, probative, and substantial evidence and was in accordance with law. As we stated in our brief, the Ohio Administrative Code defines resources to where a person has the legal ability to access in order to convert the property to cash.
So Attorney Sullivan,
Yes.
if you can address this for me, if she's unable to sell the property, explain how that is or is not legal ability to access in order to convert to cash.
She has the legal ability to sell it, and there is no joint in some of the state and federal rules. It discusses where a person does not have the legal ability to sell it. For example, there's a joint owner, and the joint owner refuses to sell. At that point, that person has no legal ability to sell the property. And therein lies the difference. That's not the case here. Ms. Gardner does not have a joint owner who is refusing to sell the property. She has legal ability to sell, as was found in Communicare and Cohen.
Is legal ability to sell defined in case law? Is there more information beyond legal ability, any context that's been provided to that?
Other than the cases in Underwood and Communicare and Cohen, that's what I'm aware of, Your Honor.
So can I ask a question? I'm sorry, but
Yes.
so what happens to a person who can't sell their property and they don't have the liquid assets to pay for care? What happens to them? How do they get care at that point?
If a property really is unsellable, then its value it has no value. If it really is unsellable, and Ms. Gardner could have provided evidence at her state hearing and that it was unsellable, that it is not, that its value is zero. At that point, it would not count toward her resource totals, because it has no value if no one is willing to buy it.
So, but if a property does have value, but they're just having trouble selling it for whatever reason, it doesn't matter if they're making reasonable efforts under Ohio Medicaid law. What happens to, I mean, they just don't get care at that point. They have this piece of property out there. They're trying to sell it. They can't sell it. Are they just left without care?
Well, Ohio could have a provision where it allows for it not to count while someone is trying to sell. And as Mr. Barnes said, it had so in the past, but that is a policy decision that it's not mandated. And that's, I think, where the difference lies here. Mr. Barnes is arguing that this reasonable efforts to sell exception is required. And at his brief on page 18 in the footnote, he points to 16 other 1634 states that exempt such property that are being sold. That is, I would note that there are 35 states and territories that are 1634 states. So the fact what 16 do is, it's not really very indicative one way or the other. But I would also note that this is the important aspect, is that at least for the states that I looked up, California, Colorado, Texas, and Vermont, that is listed in appellant's brief, they are listed under 42 USC 1396 AR2, which it allows states to, in their discretion, disregard certain property. And these states that appellant relies on, California, Colorado, Texas, and Vermont, in their discretion has chosen to do that. Ohio has chosen not to be more generous than is mandated. So it's a policy decision, and one can argue with that policy decision, but that's the difference in the argument. And that is the key, is that it's whether it's mandated versus discretionary.
But I thought, so explain to me this, Medicaid, Ohio Medicaid law cannot be more restrictive than the Social Security benefits law. And under the Social Security benefits, she would be able to show that she was reasonably trying to sell this house, making reasonable efforts, and she would qualify. But yet,
I would disagree. Oh, I'm sorry.
Go ahead. No, I mean, you know where I'm going.
I would disagree with that, Your Honor. I would, of course, we can't know since she didn't apply for SSI, but as I read the law, 20 CFR 416.1242 requires a party to agree in writing that they will make reasonable efforts to sell a property for 9 months. And that it specifically says that the time period for disposal begins on the date of acceptance of that signed agreement. So as far as I know, Ms. Gardner never signed an agreement.
What there was no agreement to sign, though, right? I mean,
well, I'm sorry, I misunderstood. You asked if she would qualify for SSI. or
You're
that was
asking, you're saying she didn't sign the SSI agreement.
So I'm arguing she wouldn't have qualified for SSI regardless because the time never started running for reasonable under the regulation. And so appellant argues that under 42 USC 1382B, that 9-month time requirement applies. And if it does, we argue it doesn't apply because it refers to conditional benefits, which are not part of the Medicaid program. But even if it does, they can't say that it applies and then say that they don't have to abide by the plain language of the regulation, which is that the 9-month period doesn't start until you sign an agreement that you'll make reasonable efforts to sell the property. Again, because 1382B, it states it can't be more restrictive, but that it has to only refer to regular benefits. It can't be more restrictive than regular benefits because there are no conditional benefits in Medicaid. And it also refers to the regulation that was established under 1382BB is 20 CFR 416.1245B1 that specifically refers to conditional benefits. It talks about the payments during the conditional benefit period, and it talks about the payments will be conditioned on the sale of the property. These are things that don't exist in Medicaid, but does exist in SSI. So there is a pretty large difference there. So then
You're arguing that the benefits that are paid as a result of the reasonable efforts exclusion under SSI are conditional,
yes,
not regular.
that's correct.
Okay.
That's correct. And while, as appellant noted, while eventually they may become regular benefits, you can't skip the conditional benefit portion, time period, the 9 months. And that's what they're attempting to do. They're trying to say, well, no, it's, it's referring to regular, but it's not. There is an exception to the conditional benefit, as I mentioned earlier, and that's if there's a joint owner, which there's a specific exception where if the joint owner will be harmed, with the sale of this property, then it can automatically be regular benefits. You don't have to go through that 9-month conditional time period. That doesn't apply here. There's no evidence of that. So it's inapplicable. So under the facts as we have them here, there would be this conditional period and it would go into a regular period. And since that doesn't apply to Medicaid, the no more restrictive language doesn't apply to Medicaid either. And this entire SSI statute does not apply to Medicaid, as is made clear. While some of it does apply, some of it doesn't. And appellant can't just cherry pick one phrase out of it and apply it and say it's mandated, because it's not mandated. Ohio can choose to, as these other states, they can choose to include this language that makes it less restrictive, but they're certainly not required to. And I would further note that if it's interpreted this way, if the court interprets it this way, it doesn't. It would seem to make the entire conditional benefits portion superfluous, because if this is, as appellant says, if it's just this is regular benefits, then what is all the language and all the regulations and all the statutes about conditional benefits about? It wouldn't make sense to include that then. And it would also seem to violate the anti-recovery provision in 42 USC 1396 PB, which in SSI allows cash, it requires a patient to repay what is effectively incorrectly paid benefits. They've been given benefits that they don't qualify for a period of time while they make these reasonable efforts. In this case, if it's interpreted the way appellant wants it to be, under Medicaid, they would be correctly paid. So someone would just get to have the benefits of Medicaid without actually meeting the eligibility requirements and have to make no payments back, which
Some states do that, right? Like, was it Michigan that doesn't require repayment?
Well, that's the thing. I didn't look up every single one of the 16 states that appellant noted in their footnote, but in their brief, but they're all under a different provision. The ones that I did look up were all under an entirely different provision of the law. So I can't say whether or not that's an accurate statement of what Michigan does, because if Michigan chose to be less restrictive under 42 USC 1396A R2, then that's their choice. And you can look at several of the states. For example, several of the states exempt reparations made to Holocaust survivors. They say that is not considered a resource. They can choose to do that or not, but it's not, that is under a completely different provision of the law, and it's not mandated. And that was also what the prior Ohio law that had this reasonable exception kind of language, that was what that was under. It was under this discretionary language, not under the language that Mr. Barnes is speaking now. So,
do you have any idea why that was taken out?
I don't. I would presume it was also during the transition between the to a 1634 state. It may have been taken out for that reason. So I don't know. It was before my time, unfortunately, so I'm sorry.
And you would argue that this is a legislative fix, not a judicial fix.
Well, yes, and as a matter of fact, there is a regulatory fix that will go into effect in April that it will allow a reasonable, they're going to reimpose that rule or a similar rule that allows for a period of time to sell. But again, that is under the discretionary portion of that will be, again, Ohio will choose to be less restrictive than is required. It's under an entirely different part of the Medicaid statute. So it's choosing to do that, just like these other states have chosen to do that, but it's not mandated and it's not required, which is the difference.
You are at your time unless the panel has any additional questions.
Thank you, Your Honors.
Mr. Barnes, you have 3 minutes remaining.
Thank you, Your Honors. Regarding 42 USC 1396A R2, that is not a completely different statute. That is actually the statute we have referenced many times in our briefs that shows this is a requirement. This is not a policy decision here. The language of that section says shall be no more restrictive. That is a requirement. It can't be more restrictive than the SSI methodology. There is a reasonable efforts exclusion or the SSI methodology. It's not a policy decision. We did do our review of those other states, and we found 16 that had explicit sections of their regulations that laid out reasonable efforts exclusion. It's entirely possible that for the remaining ones, many times from what we had found, they just reference the federal statute and say, hey, we follow the federal statutes, and they'll go into more detail on that. It could be possible they're still following some type of reasonable efforts exclusion, but whether they are or not, it is mandated. It does say it shall be no more restrictive. Regarding the new rule that came into place, again, the new rule that's scheduled to come into place, while it would fix it going forward, obviously the issue here is that Ms. Gardner was already impacted. Again, there's no conditional benefit. It just shows that there is no conflict here. I know Ms. Sullivan did bring up, it could be an issue with a payback provision. If the state thought that, they can always not have a payback provision, just like in 2016, just like they're doing now, and it's not an issue. But the main thing is that there is a requirement, it has to be no more restrictive than under SSI, and that's why there's that test. Would there be a reasonable efforts exclusion applied if Ms. Gardner was applying for SSI? Yes, there would, and that's why it needs to be here in this case. When it comes to the reasonable efforts exclusion under SSI, it is defined in the POMs as a regular benefit. It says, there's a POM section that says distinguishing between the reasonable efforts exclusion and the conditional benefits period. And it defines reasonable efforts exclusion as a regular benefit. Again, this is talking about a payback provision though, which really isn't the issue here. It's about whether Medicaid eligibility applies. And again, the requirement under 1396A is you have to be no more restricted. You shall be no more restrictive. You can be less restricted.
Mr. Burns, you are at your time.
Thank you, Your Honor.
Counsel, thank you both very much for your arguments this morning. We will take this case under submission. We will give you a timely written opinion. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Ms. Hayden, if you will bring the next parties into the courtroom. Good morning. Our next case on the docket this morning is Gauthier versus Gauthier, or Gauthier. Mr. Grossman, I'm going to ask you to try one final thing with your camera. Are you on a laptop?
I am, ma'am. Yes.
All right.
Yes.
At the very top of your screen, there is a camera slide, a little button that slides on and off. Could you try and just make sure that the camera is actually on that button?
I don't see that.
Okay, it's sort of hard to see, but if I go like this, my camera is off. Do you have that at the top of your screen?
I don't see that. I'm sorry.
All right, that's all right.
I'm not very proficient at any of this. I've never done a Zoom. I've always done it by phone when I've done these meetings, but never been on camera. So, and I didn't even have it downloaded on my computer this morning to get this. And I was going to use my wife's computer, but that would have shown my name, she told me. So then we downloaded this app really quickly. And so I'm sorry, I'm not familiar.
All right, that's fine. We can hear you perfectly. There's no need that we see you. I just wanted to try one last ditch effort. But as I mentioned, we are here on Gauthier versus Gauthier. Mr. Grossman is here on behalf of appellant. Mr. Klingler is here on behalf of appellee. Mr. Grossman, you will have 15 minutes to argue this morning. Would you like to reserve any of that time for rebuttal?
Yes, I'd like to reserve 7 minutes for rebuttal.
All right, I will keep your time, and whenever you're ready, you may begin.
Okay. Thank you very much, Judge Myers. This case has had a history. You all know about it. You've had 2 previous appeals in it. The primary point I would like to make, you've got all the briefing on it, is that we were the prevailing party on the claims on the addendum. The primary claim, if you would look at the complaint, their actual primary claim in this complaint dealt with personal property and the theft and lying about that personal property. There was both a breach of contract claim and a tort claim for conversion against Ms. Gauthier regarding those matters. The addendum claims were very, very minor, relatively speaking, but there was one very important matter involving the addendum, and that was a violation of addendum paragraph 1, which dealt with alimony. And under paragraph 1 of the addendum, Sue Gauthier was required to take $150,000 of the approximately $750,000 amount that Mr. Gauthier paid to her pursuant to paragraph 1 as alimony, which meant that Mr. Gauthier still had to report that in his 2010 tax return. This related to 2010. And he then was allowed under law to take a deduction on his 2010 tax return because it was paid in alimony. And in return, Ms. Gauthier was required to report that $150,000 alimony in her 2010 tax return that she filed in 2011, or was supposed to file in 2011. And then that all squared with the IRS. So the IRS communicated with Mr. Gauthier in April of 2013 about his tax return and that deduction and the taking of that deduction. And we then informed, I called Mr. Klingler immediately and said that Ms. Gauthier had not reported that income on her 2010 tax return filed in 2011, and to please immediately correct that situation, which would have immediately ended the IRS audit. They didn't do that. As a result of not doing that, we then sued them and mentioned this in paragraph 16 of the complaint, and said that she did not record the alimony on her taxes as she was supposed to for 2010, and did not pay the taxes on that amount. And that the IRS had audited Mr. Gauthier as a result of that. And we asked them to correct it. They did not correct it. When we alleged this, they then said in response to this allegation, and by the way, had they simply immediately corrected it, it would have been over right away. There would have been no claim on this whatsoever, no cost, no anything like that. So then what occurred is that we filed the suit. We mentioned this in paragraph 16 of the complaint, and they denied it for lack of knowledge. That's a frivolous denial. Of course, Ms. Gauthier knew whether or not she reported the income and filed her tax return reporting that income. Then once she denied that, the IRS got back to us after we had given them the information that we'd paid the $750, of which $150 was for alimony. And the IRS had one question only in response. And we've supplied all this documentation, both in the proffer and previously in the underlying suit. All they asked was prove that Ms. Gauthier received the $750. We, of course, proved that we gave the $750 to her lawyer, Mr. Klingler, but they wanted to make sure that Mr. Klingler had provided her with the $150 of the alimony. So we asked Mr. Klingler to provide us with that information, and he failed to do it. He did not cooperate. As a result of that, we then had to file a motion to compel before Judge Stitch. He then granted the motion to compel and ordered them either to be in a deposition with us or to provide affidavits verifying that they received the $150. Well, they ultimately simply provided affidavits, said they got the entire $750. That, of course, was apparently sufficient for the IRS, because when we reported that to the IRS at the end of August of 2013, the IRS then subsequently, of course, had that information. And then we've discovered in the underlying litigation, we also proffered this, that Sue Gauthier then amended her 2010 tax return to actually report the income, that is the $150,000 of alimony, and to pay taxes on it. That was the main claim on the alimony amount. And we prevailed in that proceeding before the IRS, and we prevailed upon it before Judge Stitch and in this proceeding in court by getting her to change her position and to actually report the alimony income, which she should have done at the very beginning, and she had not done on her tax return for 2010. And as a result of that, the IRS audit then ended. And the only then claim that survived that, and it wasn't a claim, it was simply that we said we had $2,500 of audit expenses to defend the audit from the joint accountant for the parties, which was SS&G. And then when this went up on appeal and we'd lost the summary judgment on this, the only thing the Court of Appeals said was it didn't find that we lost our claim in enforcing paragraph 1 of the addendum agreement. It just simply said that the audit costs of $2,500 we hadn't proved were approximately caused by her breach. Now, I don't completely understand that ruling, because clearly all of the IRS documentation we provided demonstrates that the whole point of the audit was to get at the fact that Sue had not reported the income and had not filed her taxes, and that after she did, the audit ended. But the basics of that are that we prevailed on this. It's clear we didn't get a summary judgment on it. That's true, but that's because they no longer contested it at the point of summary judgment. I mean, had they not filed their tax return in September 2013 and reported the alimony income as a result of us requiring them through the motion to compel and through this lawsuit, then of course we would have filed summary judgment, and presumably they wouldn't have objected to a judgment on that point, and we would have won this point clearly, but we won it before that. So clearly we prevailed on that, and it wasn't, we didn't breach that. Ms. Gauthier breached it, and there's no contention that she didn't breach it. She had to have breached it because she didn't file her tax return. We provided the tax return that Mr. Kunamara provided to us in a subpoena, and that's exhibit in our proffer 22. But previously underlying this, they conceded that they did not file a tax return for 2010, which was filed in 2011 with the alimony. Now,
Mr. Grossman, you have 1 minute remaining if you'd like to reserve 7.
Okay, I do want to reserve 7. And the same is true, but because ultimately what we've demonstrated is this. A breaching party, and Sue Gautier breached both addendum provisions, cannot recover as the prevailing party. Now, and in addition to that, the amount in controversy, for example, on the alimony claim was only $2,500. You're going to spend between $40,000 and $50,000 in attorney fees litigating that? That's not what actually happened. In addition, we had an absolute right of set off under the full text separation agreement incorporated into the court's divorce decree to set off the amount of their joint audit defense for audits that led to the tax refund check. And that's the only reason why we raised that issue on the addendum claim. We weren't litigating the question of her being entitled to 1/2 the refund check. That was never litigated. We agreed with that all along. That was not being
Mr. Grossman, you are at your time.
Thank you, Judge.
You will have 7 minutes when we come back.
Thank you.
Mr. Klingler, you have 15 minutes whenever you're ready.
Thank you, Judge Myers. Well, I'm not sure where to start, frankly, and I invite any questions from the court because I think Mr. Grossman's points are so out of order with respect to what happened in this litigation that I'm not sure how much time to spend on them.
I have a question then, if you're inviting one.
Yes, thank you, Judge.
Why at the fees hearing to determine the reasonableness of the fees, was he not entitled to cross-examine you?
Judge, I think all of the evidence that Judge Lubers needed to make her decision had already been presented at that case at that time. There were several affidavits.
Well, let me interrupt you. But isn't the opposing counsel entitled to probe you as to the reasonableness of your fees in a cross-examination? Whether or not Judge Lubers believed she had everything she needed, wasn't he entitled to probe that?
I don't believe so, Judge, in this case, and I can't speak for Judge Lubers, but I do know, and you do too, that there's a history to this case. There was certainly a full-blown fee hearing before Judge Foley several years ago, which I outlined in our brief, which I think it's fair to say went off the rails. There was nothing that I saw in Mr. Grossman's brief that indicated that he had evidence or reason to think that cross-examining me the same way he attempted to cross-examine me in front of Judge Foley would have somehow uncovered additional relevant evidence. There were, I think, 2, perhaps even 3 affidavits that I filed and signed under oath in this litigation with respect to attorney's fees, both at the Foley hearing and at the hearing before Judge Lubers. Mr. Grossman had the opportunity to call his own expert witness to challenge the reasonableness of the fees, which seems to me would have been more persuasive and have more weight than simply asking me questions about it. He did get to cross-examine Ms. Punzak, who was my expert witness, cross-examined her extensively about her opinion as to why she thought the fees were reasonable. There's no basis, in my view, Judge, to believe that Mr. Gautier was prejudiced by Judge Lubers not permitting Mr. Grossman to put me on the stand and ask, frankly, the same kind of irrelevant questions that had been asked to me by Mr. Grossman just a few years beforehand in the same case with respect to the same attorney's fees, although some additional fees obviously had been added by that point. So I guess my short answer to your question, Judge, is whether or not he was entitled to under these circumstances may be debatable. I think Judge Lubers, in her discretion, made a wise decision not to open this up to the same kind of thing that had happened before Judge Foley. But in the end, there was no prejudice. There's no reason at all to think that somehow I would have cracked on the stand and admitted that, yes, I overbilled, or yes, this was unnecessary. All of the time records, as I'm sure you know, if you've looked at them, I'm sure you've glanced at them at least, were fairly meticulously kept, day by day, hour by hour, descriptions of the time that was spent. Mr. Grossman certainly had all the opportunity he wanted to cross-examine Ms. Punzak about, well, why was this relevant? Why was that relevant? Don't you think this was too much time for that? There's no reason at all, Judge, to think that my testimony on that under cross-examination would have produced some kind of additional evidence that would have been helpful to Mr. Gautier.
Thank you.
Judge, I do want to address briefly what I thought was probably going to be the focus of this argument, which is the question of attorney's fees incurred and what this clause actually means in this fee shifting clause in the 2010 agreement, and what the case law has to say about that.
Before you get into that, what was your contingency agreement with her?
My contingency agreement, Judge, was that my collection of fees was contingent upon our winning the case and obtaining a fee award against either Mr. Gautier or Mr. Grossman or both.
So it was both of those things. It wasn't just you winning the case. It was also being able to obtain a fee award.
Yes,
because
Judge.
if she couldn't get the award, you weren't going to require her to pay you.
That's correct, because obviously we were defendants in this case. There was no pot of money to divide at the end, so it was not a traditional contingent fee in the sense that I was entitled to some kind of percentage. So the contingency was that what I believed from the beginning and told Mr. Grossman from the beginning before Judge Stitch, I think these claims are frivolous and I'm going to pursue sanctions if you continue. By the way, Mr. Grossman apparently had what he thought he wanted on the tax on this alimony issue back in August of 2013, just a few months after he filed the suit. So, but he didn't dismiss the rest of his claims. Then he kept pursuing them. So we didn't have any choice but to continue to defend them. But and Judge, also some more context. At the time this case was filed, Ms. Gautier, I was already representing Ms. Gautier in two separate pieces of litigation in Warren County. She was paying me by the hour on one of those and a contingency on the other. The hourly case went on for years and years. She paid me a lot of money, owed me a lot of money, frankly, and I was not going to charge her to defend what I thought was a frivolous claim. And obviously this court eventually said, well, they weren't frivolous, but under the addendum agreement, we may be entitled to fees. So that was the contingency. And I believe that this clause, the fee shifting clause in this agreement, clearly covers the fees that I incurred, even though she was not required to pay them. I did send her not invoices, but I sent Ms. Gautier monthly records, like I always do, of how much time I spent on the case. And there were some costs that she was required to pay, but not any attorney's fees. So those records were sent to her, but they weren't invoices, because at least for attorney's fees, because I had told her, we had agreed I was not going to require her to pay out of her own pocket. She couldn't have, I mean, I guess we could have just agreed that she'd owe me more and more money, but that's not the agreement I made with her. By the way, I'd like the record, Judge judges to show at this point, although the agreement was oral, the contingent fee agreement was oral at the time. Since the hearing, I have obtained a written oral fee agreement from Ms. Gauthier that simply documents the agreement that we had all along. That's not part of the record in this case. It wasn't before Judge Lubers, but I just want to state that on the record. There is now a written agreement that at least simply says, you won't owe me any attorney's fees unless we recover from this case. Now, the language in this case was negotiated by two attorneys, maybe more than two. Mr. Gross, there was a Taft lawyer involved at the time. Mr. Grossman had been, or maybe had been a partner at the time. And the language of the agreement doesn't even use the term incurred. It says that the prevailing party shall be entitled to recover all reasonable costs and fees arising out of or relating to this agreement. We could have put in that agreement, recover all fees paid by the client or recovered all fees billed by the client. We could have even said recovered all fees incurred by the client, but we didn't. We just said recover reasonable fees arising out of or relating to this agreement. And I think it's clear that the fees that were awarded by the trial court were reasonably related, were reasonable and arose out of this litigation. So I think the law on this is interesting because there's different cases, of course, from different districts that discuss fee shifting agreements or fee shifting statutes. And those statutes, first of all, 54D was amended, as we pointed out in our brief, in recent years to make it clear that fees are recoverable, costs, are recoverable under 54D, whether or not they were actually billed or paid by the client. And in addition to that, I think it's important to note that 232350, that's the frivolous conduct statute, which we're not under here, but it does shed some light on how the courts have viewed attorney's fees. 232351B3A makes it clear that under the frivolous conduct statute, even if the case is being handled on a contingent fee basis, the court can award fees based not on a contingent theory, but based on the reasonable value of the time that would have been billed, the fees that would have been billed if that agreement had not been contingent, but had been hourly or something else. So I think there is plenty of authority for this court to uphold Judge Luber's decision, which, by the way, of course, is an abuse of discretion standard. I understand that if this court decides she made a legal error, then that's a de novo matter. But with respect to her findings of fact and her analysis of what this agreement actually says and intended, the standard is abuse of discretion. I think it's clear in my mind after all this time. By the way, Forrest started this case in 2013. He started it. We didn't start it. We defended it. The claims were dismissed on summary judgment, been up to this court and back. And it's time for the court to finally to put its stamp on approval, I believe, on the trial court's decision that under these circumstances, Forrest, who lost the case, is required to pay the costs and fees that arose out of this case. And that's what we're asking this court to do.
Mr. Klingler, just one quick follow-up question. Mr. Grossman's argument that his client was actually the prevailing party because the issue of the taxes was resolved in his favor. As I understand your argument, it is, well, that was an issue, but that was dealt with early on and the litigation continued, and therefore your client is the prevailing party in the lawsuit because all of the claims were resolved in her favor at the end of the day. Is that your response to his argument?
That's my response to his argument, Judge. And this court back in 2005 in Keel versus Day said a prevailing party is one in whose favor the decision or verdict is rendered and judgment entered. That's what happened here. And we haven't argued this. They didn't raise this on appeal, but I suppose we could have gotten into a discussion of who was the most prevailing party, who prevailed primarily. But that really wasn't an issue. There was no judgment at all entered in favor of Mr. Gauthier on any of these claims. And I would.
But I think Mr. Grossman's argument would be, if I win a gigantic part of the case because your client concedes your client was wrong, I am the prevailing party. It wouldn't have happened but for that, and to force it to a judgment would be a waste of everybody's resources. I think that would be his comeback.
That probably would be, Judge. And unfortunately, I take issue with a lot of Mr. Grossman's rendition of what actually happened in the court below. But I think it's fair to say that Judge Stitch did issue an order for us to turn over some information. It was in the nature of a discovery order to turn over information. I would state that I had offered Tom to do that. You know, that is not something we needed to be required to do, but that's how, because of communication issues and whatnot, that's how it ended up. And Judge Stitch said basically, okay, give him that information. They continued to litigate that and all of the other claims that Tom now says weren't that important. Well, they were important enough to continue to litigate for years and years. So I don't believe, Judge Myers, that issue is one that is fairly characterized as Tom's client, Mr. Grossman's client, prevailing on that issue. It was one of those discovery things that comes along in litigation. And he never made any request for fees or an award of fees for what he allegedly had to do based on our allegedly frivolous conduct. So I think you're right that would be his comeback. I don't think it's substantial, an issue that's substantial enough to change any of the decisions of the court below.
Right. And you are at your time, Mr. Klingler. So thank you very much for your argument.
Thank you very much.
Mr. Grossman, you have 7 minutes remaining.
All right. We won the main point. The main point on the alimony issue was whether or not she was required and had breached the question of reporting the alimony income in her 2010 tax return, which she did not do.
Let me stop you there, Mr. Grossman, and interject a question. When was that? When did you win that point?
We won that point when she filed her amended tax return in September of 2013, and then stopped. But then after that, she started contesting the alimony characterization.
Okay, let me stop you there and ask a follow-up question. If that's accurate, that you won as of 2013, then why isn't Mr. Klingler's client entitled to fees from that date forward? Because after that, your client lost the claims.
Well, we didn't actually lose the claim. There was no, remember, your question ultimately on fee shifting is with regard to enforcement of the term of the agreement and who prevails on that in the proceeding. That he misstated, by the way, the fee shifting provision. It isn't relating to the agreement. It's relating to enforcement of a term in a proceeding or an action. Now, and after we won the main point, the only thing we requested was a damage of the audit costs of defending the audit. That is not a term of the agreement. That is just simply a damage flowing from their breach of the agreement. But there's no question that she breached the agreement, and she ultimately, corrected that breach by amending her tax return in September. After that, the only thing we were seeking was an award of a $2,500 audit cost, which you never would have spent $40,000 to $50,000 defending that. And they didn't, by the way. They
But
didn't do that.
it seems like you're asking us to kind of change the definition of prevailing party under
No,
Ohio case law,
I'm not. Well,
because you don't have a judgment in your favor.
that's
So
true.
you're asking a court to just kind of go back through and see who won the best or who won the most.
Well, it's no, because this is a matter of contract interpretation. It's not a matter of changing the law in Ohio, because this relates to what paragraph 8 is really doing. We are only, and it doesn't have to be in an action in court. It can be in any proceeding, any matter, and we prevailed before the audit in the IRS, and we prevailed in getting what the IRS was requiring in order to make sure that Sue complied with the agreement, which was to file a proper tax return and to report this income properly, which she ultimately did because we forced her to change her position. Mr. Klingler did not offer to me the information that was needed. Had they simply, when we told them about this in April of 2013, about the fact that there was an audit and that Sue had not paid the taxes and had not reported it, and had they immediately done it, the audit would have been over. There would have been no lawsuit whatsoever, and there were no fees whatsoever. The only reason why there was any of this was because they did not do that. They never offered us this information.
It just seems like an unworkable way to look at this. I mean, currently prevailing party is there's a decision or a judgment entered in the person's favor. And that seems very simple. And
but there was no judgment entered. There was no judgment entered in their favor that said that they did not have to file that tax return and report that income. That is not what the judgment was. The judgment was simply that the audit costs were not proximately caused. That's the only thing that was rendered.
What if there was a settlement? Would you say you're a prevailing party if they settled and agreed to do that?
Your Honor, obviously there was no settlement, but what I'm saying is in a settlement, I would have then taken care of whatever the issues were regarding fees. If there was some, we would have settled that too. But what I'm saying is it was an impossibility for us to do anything but what we did do. And we certainly were entitled to defend the IRS audit, to get the information from them, which they were obfuscating and not giving to us, to file a motion to compel, which gave us the ability to do this in court, which we wouldn't have had the ability to compel them to do this, which resulted in the result that we obtained. And I'm just saying that it's clear from how the parties structured this that we prevailed on this primary main point, and she changed her position. And the fact that we did that, and this is obvious, all that I'm asking for you to do is to recognize that they were not the prevailing party on this issue. The only thing that you could say that they prevailed on is something that doesn't have anything to do with enforcing a term of the agreement, because the agreement doesn't provide, the addendum agreement doesn't say, oh, we get to have our audit costs and they didn't do it, and therefore we're in there trying to enforce that term of the agreement. That wasn't what was going on. What
is our standard of review on this particular issue? Are you saying it's de novo?
Absolutely, it's de novo, and you can determine this. And by the way, the interpretation of recover, they were not obligated to pay any fees. She was not obligated to pay any fees whatsoever, and never was. That's not recovering fees. That's not what the parties intended. And that's what we so put forth in our proffer. They weren't intending that you could get recovery for something that you weren't obligated to pay, or that you did not have to pay, and that you didn't have any issues. They made this thing a very odd thing. And the courts don't say that, oh, you can get a contingency fee thing on an hourly rate thing. What the Ohio Supreme Court has held is that you can't shift to another side a contingency fee arrangement unless they've agreed to it. And they, of course, we didn't agree to a contingency fee shifting provision in this case. We agreed to pay something that she actually had paid or incurred and obligated to pay as a recovery. That's not what happened. And they changed the entire syntax of that sentence by claiming that recover it does not relate to recovery for fees. So, and we've explained this in our brief. I would go back, though, to some of the points that they've made, if I could.
Mr. Grossman, you have 1 minute to do that remaining.
Okay. I will try my best then to do this. This is really important. Folks, I'm sorry, judges, this is a lot of money for a client of mine who was simply trying to collect his personal property, which was basically what this case was all about, and where she lied in the answer, she lied in her interrogatory, she lied in her deposition, she lied under oath about this, she lied about in her answer on the question of alimony. Throughout this proceeding, she was dissembling, obfuscating, and lying, and then all of a sudden there's this decision that we have to go to the Domestic Relations Court in Warren County on jurisdictional priority, which was not accurate. You cannot go to any domestic relations court, whether it be in Hamilton County in your district or Warren County in the 12th district, and seek damage awards. And so, I mean, I'm sorry that the Court of Appeals first held that, but I know that Judge Myers in her opinion indicated that it was arguable that we did have jurisdiction here. And there was never a sanction properly awarded with regard to us, and that was reversed. And all they really did to get fees is they said, oh, well, there's one-third, there's one-third claims on the personal property, which actually is almost the entire case was about personal property. That was almost what all the fees were about. None of it was about this matter that we're talking about with $2,500 of audit costs, which had nothing to do with enforcing a term of the agreement, nothing. So I'm asking the court to recognize what really was going on, and under this contract you have a de novo review of it. There was no recovery of fees in this case because she never was obligated to pay fees, which we didn't find out about. That wasn't in the first matter involving Foley, but we didn't find out about this until this matter. And I did not have extensive right to cross-examine her expert. I was given 15 minutes. I was completely truncated in what I was allowed to cross-examine the expert on. I was not able to delve into the actual fees that they pay, the actual hourly amounts that they spent, the actual work that was being done. None of that occurred. I would have
Mr. Grossman, I'm sorry to interrupt you mid-sentence, but you are now two minutes over your time, and so I'll let you just finish that thought, and that your time will be up.
Okay, well, thank you for your consideration today. This is a travesty of justice, what has happened in this case. My client did nothing wrong. He did everything right. He did not breach. Ms. Gauthier breached, and they're not entitled to fees. Thank you.
All right, thank you. Mr. Klingler, Mr. Grossman, thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written decision. Ms. Hayden, if you will bring the next litigants into the courtroom.
Thank you.
Mr. Cumming, I don't know if you wanted your camera on or not, but it is not on at the moment. Our final case for argument this morning is State versus Johnson. Ms. Spriggs is here on behalf of Mr. Johnson. Mr. Cumming is here on behalf of the state of Ohio. Ms. Spriggs, you will have 15 minutes to argue this morning. Would you like to reserve any time for rebuttal?
Yes, please, if I could reserve 3 minutes.
All right, and I will keep your time whenever you're ready.
Thank you so much. Good morning, Your Honors. May it please the court, Addison Spriggs on behalf of Kevin Johnson. Mr. Johnson is entitled to an evidentiary hearing. He submitted new evidence through his post-conviction petition, which contains sufficient operative facts that supported the grounds for relief and, if proven, warranted an evidentiary hearing. Trial counsel's failure to inadequately challenge Detective Horning's testimony prejudiced Mr. Johnson a number of ways. Trial counsel was unable to prevent Detective Horning from falsely testifying or misleading the jury with her testimony. Trial counsel was unable to undermine Detective Horning's credibility. Trial counsel was then unable to challenge the sole evidence that connected Mr. Johnson to the drugs in the vehicle, which was the fingerprint identification provided by Detective Horning. The lower court determined that res judicata was a threshold issue in this case and resolved the case on those grounds alone. There were no findings of fact or conclusions of law, which are required by this court, as it recently stated in the State v. Lavender case. Mr. Johnson attacked the testimony of the state's fingerprint examiner in two ways on direct appeal. He argued that the state violated Criminal Rule 16K by failing to provide a timely expert report, and he argued that the fingerprint examiner did not meet the reliability threshold as required by Evidence Rule 702. These issues were preserved in the trial record, which is why they were raised on direct appeal. The issues in Mr. Johnson's post-conviction petition are related to those issues only insofar as they too address the fingerprint evidence. However, unlike the direct appeal assignments of error, the claims raised about the fingerprint evidence in his post-conviction petition rely on evidence that cannot be found in the record. And that's why res judicata does not apply.
Ms. Briggs, may I interrupt and ask a question? You mentioned in your brief that the res judicata issue is currently before the Supreme Court. Are you suggesting that we hold our decision until the Supreme Court decides that issue?
I do think that the Blanton decision will directly impact this case. And so, yes, I think the court has a couple of options. It could hold for the Blanton decision, specifically the first proposition of law in Blanton will directly affect this case. Otherwise, this court could remand under the Lavender decision and ask the court to consider conclusions of findings of fact and conclusions of law, which are required. So I think those would be the two options.
Thank you.
Thank you. I would just like to say, because the claims in the post-conviction petition were supported by outside evidence, particularly that of an affidavit of an expert who said that Detective Horning's testimony did not comply with the state of the science and the state of experts in her field, the trial court improperly resolved this case on the res judicata grounds. So Mr. Johnson would ask that this court either hold for Blanton or remand on the basis of Lavender and request conclusions of fact and findings of fact and conclusions of law. Thank you.
I just ask with regard to your ineffective assistance of counsel claim, just so that I understand what you're arguing. I know you're asking to have it remanded for an evidentiary hearing, but the argument in this case, we have trial counsel who actually did challenge the expert, going so far as having a Daubert hearing and cross-examining the expert witness for the state on the fingerprints. Is your ineffective assistance of counsel claiming basically saying he didn't do enough? Or, I mean, is that the argument here?
So I think what happened was there was a discovery violation and counsel was ill prepared based off of that discovery violation. It was clear that he was scrambling and he knew enough that this testimony was improper and was false and misleading, but he wasn't able to be prepared to adequately cross-examine and to undermine the testimony of the expert. So he tried, but ultimately he was still ineffective because he wasn't able to properly impeach and properly exclude some of this false and misleading testimony.
And the discovery violation, that was raised on direct appeal.
That was.
I guess we found that there was not enough information in the record to really determine that whether there was or was not a discovery violation.
Correct.
Okay.
Thank you.
Thank you.
All right, and Ms. Spriggs, I will calculate your time remaining, but it will be more than 3 minutes.
Thank you, Your Honor.
Mr. Cumming, you have 15 minutes to argue.
Good morning, Your Honors. Your Honors, this is a very straightforward application of res judicata. I think the trial court was entirely correct and properly dismissed this petition on that basis. There is no demonstration of a violation of a duty here. The trial counsel was all over this. I think it just didn't turn out the way that the defendant would like, but just having a different approach or a second opinion, second guessing, that doesn't demonstrate ineffective assistance of counsel.
But shouldn't there be an evidentiary hearing to kind of flesh that out?
Well, no, because that's what the trial was for. They did flesh this out. at the trial. They had it like, as you noted, they had a Daubert hearing. This fingerprint expert was cross-examined at trial. And that's where you test the reliability of her conclusions, her credibility, her process and her procedure. That was the evidentiary hearing.
But not on ineffective assistance. I mean, the whole issue is they're saying that the trial counsel didn't challenge this discovery violation, or there apparently there was not a discovery violation. The trial counsel wasn't prepared. All of that, shouldn't we just remand it to have an evidentiary hearing? Why not in this case?
Well, because application of long established case law instructs us that having a different approach or a different expert opinion as to how something should be done doesn't even meet the threshold of demonstrating ineffective assistance of counsel. If that were not the case, all of these cases would turn into a never-ending battle of the experts. And that's something that this court's warned against. The Ohio Supreme Court has warned against it. Specifically, this court said that in Clemens. It was a 1999 case. But at any rate, this material that is being referenced in this post-conviction was available at the time of trial. And it was used to a large extent by trial counsel. Because it was available at the time of trial, res judicata bars its discussion in a post-conviction. This was available at the time of trial. These materials are not new. Just because she says it's a new evidence, it's not. This stuff has been out there long before his 2017 trial. And if you look
Mr. Cummins, do you agree with Ms. Spriggs that this issue the res judicata issue will be decided by Blanton?
It's possible, Your Honor. It's possible. I don't think so, but it's possible. It certainly is possible. I think that this court could apply long-established res judicata law and be comfortable in dealing with this appeal in real time right now. The state does not think it's necessary to wait for that decision, but it could be possible. It could affect it, of course, yes.
Thank you.
But I do want to state that just look at the syllabus paragraph of State versus Perry. They say that if these claims were raised at trial or could have been raised at trial, and we're not talking about on appeal, we're talking about at trial, and all this material that is referenced and appended to this petition was available back then. And the defense counsel at that time did use it to a great extent. So this is something.
But that's the argument. The ineffective assistance argument is that there was all of this information available and that counsel was ineffective in utilizing it or didn't utilize it all, didn't effectively cross-examine. I mean, that's the issue.
Well, I understand your point, but there's an additional prong to this. In addition to the fact that this is barred because all this stuff was previously available, that's what res judicata does. It bars the consideration of it. You're going to the ineffective assistance of counsel aspect of this, and I understand that. Case law exists from the Ohio Supreme Court that goes to this issue, and it says that it is not ineffective assistance of counsel to fail to challenge the reliability of fingerprint evidence. And I think there's a couple of cases I cited, State versus Faust was one of them. It's a long established science. And the Supreme Court of Ohio has said that it's a wise tactical decision often not to challenge the fact that fingerprint evidence is unreliable because it's so well accepted that it may not be a good strategy. And I think that's why the trial counsel in this case didn't go after reliability of fingerprint evidence in general as much as whether or not this lady was actually an expert. So
you're arguing that that failure to properly challenge fingerprint evidence could never be an effective assistance?
No, I'm just saying that there's case law out there where this has been specifically discussed, and they've said because it is such a well-established science, it's a tactical decision and it's a reasonable one not to challenge the science. Yes.
But
So
how do we know if it was a tactical decision or not unless there's an evidentiary hearing?
well, I don't think that the testimony that would be obtained would go to anything substantive or demonstrate any prejudice. I think it's important to step back in this case, and I believe that Judge Zayas Judge Krause, you were both on this case initially on the direct appeal. And if you review the evidence, the fingerprint evidence was not critical to this case.
I was going to ask you that. What other evidence? Because it was major. It was a major piece of evidence. But what else was there?
It was a piece, but you had constructive possession of the bag of cocaine because he was driving the car in which the cocaine was found. He was in close proximity to it when he was pulled over. And this court discussed that specifically. And it actually
But
led.
isn't it also consistent with his notion that or his assertion that his brother had driven the car earlier that day? And we do know that that brother had a prior drug offense on his record, and that his brother did plead to the drugs that were found in the home. So what I'm saying is that that evidence was consistent with more than one theory. True,
But we have more. When this court reviewed the record, I think on the sufficiency claim back then, the officer that pulled Johnson over testified that he was seen making a furtive gesture beneath his driver's seat. So this is another part of this totality of circumstances that leads to a conclusion that he knew it was there and he knew what it was. Also, if this court looks back to State's Exhibit 18 at the time of trial, the defendant actually tells the officers at the scene that he is taking responsibility for the car and what's in it. And I think that when you put all these circumstances together, aside from the fingerprint, you've got constructive possession, close proximity, you've got a furtive gesture, which indicates he knows what something's underneath him and he's put it there for a reason. And at the scene, he says, hey, anything in the car, I'm taking responsibility for it. You put all that together, I submit that this fingerprint evidence is not critical. And that was the court's conclusion in State versus Faust, that even if you wanted to talk about the fingerprint issue, it wasn't critical to that case either, because the defendant admitted going in the basement. So it was going to be.
The way the appellant characterized the fingerprint evidence in the brief was that it was a significant factor.
Oh, sure. Absolutely. That would, if I was defendant and defense counsel, I'd do the same thing. But I'm just, as the state, I'm pointing out to the court that it's not that critical. There's a lot of other circumstantial evidence that proved his knowledge and possession. And that's why this court, I believe, noted constructive possession in the opinion. It led with that before it even talked about the fingerprint evidence.
And I would assume that you submit that looking at this evidence in light of sufficiency is different than what we would be doing here today.
Well, in the sense that I think you have to analyze this as far as, is there demonstrated prejudice? It's already been decided that there was sufficient evidence to prove that he possessed the cocaine. I think what's on the issue on the table now is has Johnson demonstrated that his counsel violated a duty to him, and moreover, did that violation prejudice him? And it's the state's submission that he has not demonstrated either.
And that's for ineffective assistance. With regard to the hearing, would you submit that we would have to determine whether there was substantive grounds for relief?
Well, I think there has to be, yes. This court has to look at this and say, there's a substantive claim here that we need to find more out about. If this court thinks that's the case, then an evidentiary hearing would be appropriate. It's the state's position that's not the case here. There's no substantive claim here. Everything that they're bringing forth here was available. It's barred by res judicata. The Ohio Supreme Court has told us it's not ineffective for a counsel not to pursue a reliability of fingerprint evidence defense. So they've actually spoken to that direct point. And the failure to put up jury instruction before the jury, that's clearly based on barred by res judicata, because that was in the trial record.
However, these 10 documents that were submitted with the motion, they were not part of the record with regard to the trial. Is that correct?
Correct. They were not admitted. Some of them were referenced, but the trial counsel did not admit them, so they were not part of the trial court record. That's correct. but they were referenced, a lot of them. And that just goes to show that they were available. They were used by the trial counsel to some extent. And that's why I stress the State versus Perry decision, where it says, hey, look, if this stuff was available at the time of trial, it's not appropriate for post-conviction.
Do you remember on the Daubert challenge, was the state's expert challenge based on just her qualifications, or was it her methodology that was challenged?
I think it was, well, I think it was her qualifications. I think they were arguing that she didn't have sufficient certification and didn't have sufficient experience doing all of these things.
So trial counsel did not challenge the methodology and try to exclude her opinion based upon some kind of faulty methodology.
Not at the Daubert hearing. I think he went into that at the cross-examination at trial. And I think that went to the credibility. Is this lady, does she know what she's talking about? Should she be believed? Of course, that's for the trier of fact. And I think that's what this court decided, that was up to the trier of fact, and they must have believed the expert lady, and they, well, and I don't think they needed to, but it can be assumed they did.
Am I remembering the record correctly that this was her first time testifying with regard to fingerprinting analysis?
No, I think that she testified that she had done this at least 6 or 7 prior times, and it might have been more than that. But my opposing counsel might know that, but I know she at least referenced 6 times that she testified to this before. I don't have anything else to add, Your Honors, unless you have a specific question.
Any other questions for Mr. Cumming? Thank you. And Ms. Biggs, I have calculated you have 9 minutes remaining if you'd like to use them.
Thank you, Your Honor. I do have a couple of points I'd like to make. I think it's worth noting that the state has never said that Detective Horning testified correctly. When she said she was 100% certain that the fingerprint on the bag was Mr. Johnson's, that is absolutely false testimony.
Wasn't she cross-examined on that though?
So she was defense counsel attempted to cross-examine her on that, and attempted to cross-examine her with some evidence and was precluded from doing so by the trial court. He tried to admit some evidence, that was attached in the post-conviction, and the trial court did not allow him to do so and to not proceed down that line of questioning. So that again is one of the issues in this case. I'd also like to point out that State v. Bunch, currently before the Ohio Supreme Court, is directly on the issue of whether cross-examination of an expert is enough. And here what we have is an expert, the affidavit of Michelle Triplett, who says the methodology and the testimony of this witness does not comply with the science and the state of how an expert should testify. That was appended to the post-conviction petition that was not before the trial court. To Mr. Cummings' point about some of these documents being available at the time of trial, that's not the standard. It's whether or not they are in the record that would preclude, that would determine the res judicata issue. Just like another post-conviction case where, potentially you have a witness who didn't testify at trial, their knowledge is available at the time of trial, but whether or not it's included in a post-conviction petition and properly before the trial court and admitted into the record determines whether or not it can be raised on direct appeal. Here, all 9 of the documents that were appended were not in front of the trial court, were not included in the record, and could not have been raised on direct appeal.
Would trial counsel, would they have had any notice that that Horning would have testified on the 100% certainty?
They could not have had any notice of that sort of testimony. That would have been something that would have had to come, in the moment. But again, if they had had an expert on the defense team who could testify that that's not proper testimony, that is actually a false statement, that's where an expert would have come in and rebutted that and undermined Detective Horning's credibility. Also, we are not challenging the reliability of fingerprint evidence, of all fingerprint evidence. We are challenging the reliability, the methodology, and the blatantly false testimony of Detective Horning, not of all fingerprint evidence. And so Mr. Cummings misstates that that's what we're attempting to do. That's not what we're attempting to do. The other thing I'd like to point out is that this court shouldn't decide the merits. It's simply the res judicata issue and whether that was appropriate. As the Lavender case said, if the trial court doesn't consider the merits of the argument first, it should be remanded for findings of fact and conclusions of law on the merits, which is this court, the trial court, did not consider the merits of this case and simply issued a decision on the res judicata issue. If there's nothing further, I ask that you either stay this case for the decision in Blanton or remand on the basis of Lavender. Thank you.
Any other questions for Ms. Briggs? Counsel, thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. We'll conclude our arguments this morning for the First District Court.